Right. So in addition to my full-time job as the Director of Law and Public Policy for ARPA Canada, I also teach a university course at a university in Ottawa. And I put this question to my students. The question is, has Christianity been a positive cultural force in Canadian law and policy? Has Christianity been a positive cultural force in the development of Canadian law and public policy? So I asked my students to write a 700-word essay answering that question, yes or no. And half of my class, exactly half of my class, said yes, Christianity has been a positive cultural force, and half of my class said no. Christianity has not been a positive cultural force in Canadian law, and by that they did not mean that Christianity just hasn't been a force at all or is not a force any longer. Rather, half of my class argued that Christianity has in fact been a negative cultural force or a negative impact on Canadian law. I teach my course at a Christian university. My students are Christians, and yet half of them believe that Christianity is a negative cultural force in Canada. Why? Well, the two main reasons that my students gave were first that Canadian Christian leaders played a role in the residential schools affair, and that's a fair critique. I think it's a critique that's fundamentally misunderstood, and I will touch on it briefly later in this lecture. And then the second reason they say is because of the treatment by the church of the LGBTQ2SIA+ community. That's their reasons why they think Christianity is a negative cultural force. The reason I think that students believe that Christianity has been a negative cultural force, though, is because that's also part of our social imaginary. There's just this sense within Canadian public life that Christianity is old-fashioned and a negative force, and we need to move away from that. What I want to show you this afternoon is, well, what happens if we do, in fact, believe that Christianity is a negative cultural force? What happens to our law, especially around sexuality and the family? What happens when we move away from the cultural foundations, the Christian foundations that our Canadian laws were built on? Do things get better or do things get worse? I will argue that the impact on law when we move away from Christianity on sexuality, identity, human rights, the family, when we throw all that through the shredder, which is going on right now, it's not going to be pretty. So here's my outline. I want to talk a little bit about family structure as it's related to the law. I'm going to talk about family relationships in the law. I'm going to talk about religious codes and institutions and how Canadian law is engaging with those. I'm going to talk a little bit about pastoral counseling. And if we still have time, which we probably won't, I'll also talk about prostitution and criminal law and how that has changed because of our cultural and philosophical assumptions around sexuality and identity. Okay, so let's start with family structure. Okay, well, what is the family? How would you describe the family? I know it's right after lunch, you got full bellies, you're probably feeling a little bit sleepy. This is the worst lecture slot to have, but it was given to me. It was assigned, not like my sex. And so how would one of you describe the family? What is the family from a biblical perspective? Anyone want to shout something out? Anyone dare? Family? All right, I'll do it for you. All right, the family, I think, generally speaking, we say the nuclear family would be a man and a woman and any children, adopted or biological, that the Lord gives them. That would be a Christian definition of the nuclear family. You can expand it if you want, and you can add grandparents and uncles and aunts and nieces and nephews and so on. But that's the family. We kind of understand, take that for granted, okay? All right. Now, the Christian Revolution 1,500 years ago made that just a natural, normal way to think about the family. Before the fall of the Roman Empire, though, that wasn't necessarily an understanding of the family. The institution was not a very important one in certain cultures, and could easily be ripped apart through institutions like slavery and so on. There wasn't a high regard for the family. There was a high regard for the paterfamilias, for example, the leader of the family within Roman culture, who could do whatever he wanted with his children and his wife, including he could sexually abuse them, he could kill them if he wanted to. That was all okay. So there's a high regard for the head of the household, the paterfamilias, but for the family as an institution. And it was the Christian Revolution 1,500 years ago that really brought about a protection for that as an institution, particularly for the well-being of women as wives and mothers, and for the well-being of children. You disregard the family, it's women and children in particular who bear the brunt of the pain and the suffering. Okay, so how has Canadian law then interacted with that Christian institution? Remembering what I said in the first lecture about how some philosophers feel that this institution is an oppressive structure that's restricting our freedom, especially our sexual freedom. Well, way back in 1968, which is an age and a bit ago, divorce for marriage breakdown was legalized. Okay, so before 1968, marriage law and family law said that divorce is allowed for the two reasons laid out in Scripture. That is, if a man abandons his wife, like takes off and disappears, so abandonment of the marriage, and then the other one being sexual infidelity, sexual infidelity. Okay, so before 1968, you get a divorce for one of those two reasons. After 1968, they expanded it to say also for marriage breakdown. So a loosening around the definition of marriage as being this committed, lifelong relationship until death do us part. This was also the time where we get this very famous speech. Hopefully the sound works. We'll see from Pierre Trudeau, who was at the time Justice Minister, actually, just before he became Prime Minister.
Of the criminal code since the new criminal code of early 1950s, and in terms of the subject matter it deals with, I feel that it has knocked down a lot of totems and overridden a lot of taboos, and I feel that in that sense it is new, but it's bringing the laws of the land up to contemporary society, I think.
Shucks, I hate it when I do that. I meant to pause it because he's mid-thought. I wanted to summarize what he's saying. 1 second. So what he's saying is he's introduced this total criminal reform law, and the line he just used there was it's bringing the law up to where society's at, right? We're going to evolve the law around sexual taboos to catch up with where society is at. So there's a big debate in cultural philosophical circles. What comes first, law or culture? What changes first? Does culture drive changes in law or vice versa? Well, just hearing what he had to say, it seems like culture was already changing and he's changing the law to keep up with the culture. I think it's actually a bit symbiotic, but anyway, let's hear what else he had to say.
Extensive revision of the criminal, and in terms of the subject matter it deals with, I feel that it has knocked down a lot of totems and overridden a lot of taboos, and I feel that in that sense it is new, but it's bringing the laws of the land up to contemporary society, I think. Take this thing on homosexuality. I think the view we take here is that there's no place for the state in the bedrooms of the nation.
Said, and it didn't pause it again for me, but anyway, he said, there's no place for the state in the bedrooms of the nation. Have you heard that saying before from Pierre Trudeau? It's probably one of his most famous things that he's ever said, and that's where most people cut off the broadcast. But he actually says something right after it. Does anyone know what he says right after that? No? Okay, I'm going to play it for you. Here we go.
What's done in private between adults doesn't concern the criminal code. When it becomes public, this is a different matter.
Yeah? So the state has no business in the bedrooms of the nation. What people do in private between consenting adults, that's between them. When it becomes public, however, that's a different matter. That's what he says. Anyone notice what goes down Main Street in the month of June in pretty much every major city in this country? That seems to me rather public. Pierre Trudeau said at the time, in 1968, when he decriminalized homosexuality, he said, well, as long as we can just keep it private in the bedrooms of the nation, that's okay. If it becomes public, that's another matter. Well, it has definitely become public. All right, so 1968, marriage breakdown is the expansion for divorce, and also the legalization of homosexuality. In 1986, we get a further expansion of the divorce law. It's now allowed for no-fault divorce. So that means that you don't need to have either one of the partners can seek a divorce. You don't need the consent of both to get the divorce. And simply, all you need to show for a divorce is that the marriage is no longer working and you've lived separately for a year. If you check those boxes, then you're able to get divorced. Again, eroding the idea that marriage is until death do us part. The permanency of the institution is undermined. Then, a decade or so later, we have same-sex adoption legalized not by Parliament, which drafts the laws, but rather by a judge in Ontario. And there was a case involving adoption where a gay couple was denied adoption. They weren't allowed to adopt in 1995 or before 1995. And a judge said, well, that's discriminatory. It discriminates against gay couples who should be able to have children too. So what does that do? What happens in the law in that moment when a judge makes that kind of a ruling? Well, two things happen. First of all, it shifts the attention in adoption away from the child and toward the adult, right? Because if you're saying, oh, the problem here is that adults don't get to have the kids that they want to have, it shifts the focus away from the child who is in need in an adoption situation, and it looks at the adult and their wants, right? But the second thing it does, it also says to the child, moms don't actually really matter, and dads don't actually really matter, right? Because if you can have two moms, that means you don't really need a dad. And if you can have two dads, you don't really need a mom. And so it's no surprise at all that a decade later, we have the legalization of same-sex marriage in Canada, which again, focuses the law, changes the law pretty radically to say, look, marriage is just between two adults who love each other, want to hang out with each other, be with each other. It's completely divorced from biology, and it's also completely divorced from procreation and the raising and nurturing of children. That's one of the public goods of marriage, is to make sure that every child is known and is nurtured by both their mom and their dad as much as is possible. So for me, I think the bigger change was actually in 1995, not in 2005. 2005 was just a natural outworking of the ruling in 1995. Then a little while later, 7 years later, in Ontario anyway, we added these terms, gender identity and gender expression, to the Human Rights Code. So again, a change in the law where we're now saying a protected identity, a core identity of who you are, is going to be listed in the Human Rights Code, and that's this idea of both gender identity and gender expression. And we're going to put that on the same level as your race or your ethnicity or your religion or your biological sex. It raises it to that level and it embeds it in law. And then in 2016, we get the All Families Are Equal Act passed into law in Ontario. Now, for anyone who's heard me speak on this one, you might appreciate this demonstration, because instead of me trying to explain to you what the All Families Are Equal Act does, I'm going to show you instead. So I need a few volunteers. So I need a husband-wife couple. And Pastor Brian, are you here with your wife today? Can I borrow you up front here? Okay. And then I need 1, 2, 3. I need 4 men and 3 women. Random. Ideally, you're not related to each other or anything like that. Okay. So okay. Got 1, 2, and Paul is 3. I need, yes, please, 4, so that's 2 men. I need 1 more guy, 5, thank you, and I need 2 more women, please. And so you'll stand on this side, on the far right, and we're going to have people on the far left over here, right? And I got 1, 2, 3. I need 1 more woman. 1 more woman, any woman will do. Perfect, thank you so much. Okay, and everybody can see them clearly? Do you want to actually stand in front of the pulpit? That would be great, thank you. Okay, so what does it was Bill 28, the All Families Are Equal Act. What did it do? Okay. Well, what it said is that, okay, we have a natural family over here, loving husband and wife, committed to each other, paragon of virtue and so on. This is very good. But that's under-inclusive. It's old-fashioned. We've got to, expand our horizons here. And so we're going to allow for a new type of family. So we're going to allow for something called a preconception parentage agreement to be drafted by up to 4 adults. Okay, so we're going to take adult 1, adult 2, adult 3, and adult 4. These 4 people together are going to sign an agreement together called a preconception parentage agreement, which says that the 4 of us are going to parent and become parents of a child not yet conceived. They don't have to live together. They don't have to be married to each other. They don't have to even really know each other in any big way. They might be co-workers or neighbors or whatever. It doesn't really matter. The four of them said, hey, let's make a baby. And we're going to do it, and we're going to sign this agreement. It's called the Preconception Parentage Agreement. Okay, but how do we get the baby? Well, we get the baby, we can have the baby conceived naturally. We can have the child created in vitro or whatever. So this is where three more adults are going to come in. We're going to have a surrogate, perhaps, right here, who's going to carry the baby for this foursome. And we're going to have an egg donor over here, and we're going to have a sperm donor over here. And this whole arrangement we're going to call a family. Now, of course, like I said, it's not just about the adults in the relationship. Of course, it's about babies, right? You can get anything at Walmart these days, including a baby. So when you have the All Families Are Equal Act, sorry, ran out of diapers.
We're used to that.
Oh, you're used to that, okay. So this is the point that is lost on lawmakers, because they say, look, we're going to be so progressive and we're going to develop the law in an inclusive way, and look at this wonderful arrangement of all these consenting adults that want to do this thing together, be a family. And they totally lose sight of the one that the family is all about, which is the child. So I want all of you, by saying yay, if you agree, answer this question, yay to this one or this one. I'm going to ask the question. All things being considered equal, by the time this child reaches 18, adulthood, will this child be better off than that child? If you say this child, say yay. Yay. All right. And if you think this child will be better off or equal to that child by the time they turn 18, please say yay. Pretty close. Let's try it again. No, all right, obviously, right? And that's what should concern us, because the Lord God, when you read his word, how many times, over and over and over again, his heart is for the vulnerable. His heart is for the child, right? Look what Jesus says about the children. He says, if you cause one of these little ones to stumble, it would be better for you that a millstone is hung around your neck and you're tossed in the deepest part of the sea. Why? Because the wrath of God against somebody who would cause harm to a little innocent child, you don't want to even think about it. And that's what we have to be concerned about. Why will this child be better? Because God designed human sexuality to produce a human being. That's how new image bearers of God are made, is through the sexual intimacy of a husband and a wife. This child will know his dad, who is half of his biological makeup. This child will know his mom, half of his biological makeup. This child will have a dad and a mom who love each other and put each other first. This child will, Lord willing, assuming no tragedy, will have a mom and a dad in their life, in their same home, day after day, for pretty much their whole childhood. This child will do so much better than this child. This child doesn't necessarily have a biological connection to the four parents. It might be a sperm donor, it might be an egg donor over there. This child will be intentionally ripped away from the only human being that they know for the first 9 months of their life, a surrogate mother. Intentionally separated and placed with four people they have no connection with, no biological connection. These four adults don't have to live in the same home. This child could be floating from one home to the next for up to 4 homes, no requirement for them to be together. There's no connection between these four that they're committed to each other. There's no marriage here. There's no commitment there. That child, of course, is not going to do as well as this one. And yet our policymakers and our lawmakers are totally blind to the child, and instead they want to look at the adults. What will make adults happy? That's a massive revolution, and bad ideas always have victims. Thank you. You can turn in your children to the state. Thank you. Thank you. Bad ideas have victims, right? How many children will have to suffer before this experiment is exposed for the fraud that it is? All right, so that's family structure. We've kind of blown that up. What about family relationships? Well, that too, we're trying to undermine, it seems. So we have 68 to 2012 with these changes, 2016, All Families Are Equal Act. Incidentally, look at the title of that act. Right? That's a moral statement, isn't it? They're saying this family over here is equal to that family over there. If this child does better than this child, the messaging goes, is that the only reason this child here doesn't do as good as that one is because we're a bigoted society. We're not tolerant enough, inclusive enough to accept this child and the different style of family that they have. Okay, but it continues. The very next year in Ontario, they passed Bill 89, which interferes with children and their parents. Okay, so Bill 89, it amended the Supporting Children, Youth, and Families Act by incorporating human rights law into family law. So that might not sound bad at first. It's like, okay, human rights, children should have human rights because we should protect their lives and their needs and so on. But it's actually really quite bad because human rights statutes protect you against your employer. So they protect against discrimination in employment, in accommodations, or in services, okay? Employment, accommodation, or services. So that means that if your boss is treating you poorly, let's say you're a woman and you work for a boss and he pays all the guys $3 an hour more than you simply because you're a woman, that could be discrimination. You could go to the Human Rights Tribunal and say, hey, look, like this is an issue that boss won't pay me properly, etc., right? Discrimination on the basis of sex. Or you go to a restaurant and say, sorry, we don't serve people with your color skin here. Go eat somewhere else. That's discrimination on the basis of ethnic origin. That would be a problem. You could go to the state for redress. But what here is happening with Bill 89, and this is a past law, so this is a changed law, is the Children, Youth, and Families Act now says that so also, just like your employer can't discriminate against the employee, just like a service provider like your mechanic or your restaurateur can't discriminate against the people they service, so also parents cannot discriminate against their own children on the basis of a long laundry list of identity factors. In that list includes gender identity, gender expression, and religion. Now, most of the list doesn't make sense anyway, like, for example, discrimination on the basis of race. That's in there, but most parents are the same race as their children, so that's not exactly an issue. What is an issue is if I, as a parent, have a different understanding of who my child is a biological boy, and he's a boy, and he wants to identify as a girl, then there's potential for conflict there. Who is the one who mediates the conflict and discrimination claims? It's the civil government, the state, right? They're the ones who are going to come in. So this is an insertion of the civil government into the family relationship. When asked about this, the Minister of Children and Youth Services at the time, in this time, 2017, it was a Liberal minister. The minister said this, Michael Couteau was his name. Okay, he was asked, what happens if a caregiver has a different view of gender identity and gender expression than a child? This is his answer. He said, I would consider that a form of abuse when a child identifies one way and a caregiver, a parent, is saying, no, you need to do this differently. If it's abuse, and if it's within the definition, a child can be removed from that environment and placed into protection where the abuse stops. Now, the Human Rights Code, it's not supposed to tell you how to raise your children. It doesn't apply to parents. It's not supposed to. But Bill 89, what it does is it extends those modern notions of equality and permissive sexual ethics and trans-affirming mandates, and it incorporates it into the family, and that hurts children. Okay, and this, I'm not sure if any of you, like little red flags are going off here, not just for yourself, but because we've done this before in Canadian history. Okay, so a quick little history lesson on residential schools. This is the part they never tell you. It's from the 1830s to the 1850s, residential schools, Christian outreach schools for First Nations children in Canada were voluntary. They're completely voluntary. They're run by missionaries. And they were enthusiastically supported by First Nations communities. They liked the schools because the schools were teaching their children how to read and write and do arithmetic and to get ahead in the mid-1800s. In 1846, the government first started funding the residential schools. Before that, they were run on the donations of Christians. After this, the government starts funding them. And then in the 1840s and 50s, there's actually treaties, the first numbered treaties between First Nations and the Canadian government. The First Nations were asking for their schools to be funded. That was part of the treaty arrangement. Okay, you can have our land if you pay for the schools for our kids. Okay, again, you're probably not told that. But then something changes in the second part of the 1800s. Okay, something changes. where First Nations parents are requesting those schools to be day schools on reserve. The government changes their policy and says, we're not going to have them as day schools, we're going to make them residential schools. Children sleep at the school, and off reserve, away from the home. And the government passed these harsh compulsory attendance requirements so that children aged 7 to 15 had to attend by force, okay, compelled by force. What caused that shift in the 1850s? That's when the human rights abuses begin. Well, the change after 1850s is a change in ideology, and that is the acceptance among Christians and non-Christians as well, the unbiblical idea of social evolution. Okay, Darwinian evolution was biological, but very quickly it transcended from biological to social. And so some progressive or intellectual types said, hey, if Darwin is right about biological evolution, then it might also apply to people groups, social evolution. And we can force the First Nations child, or the native child, or the Indian as they were called then, we can force them to evolve faster through our programming, through our residential schools. Okay, this was an unbiblical idea. We allowed an unbiblical idea from Darwin to enter into Christian thought in the late 1800s, and it caused all kinds of destruction. This is what somebody like Hector Langevin said back in 1883. He said, in order to educate the children properly, we must separate them from their families. Some people may think that this is hard, but if we want to civilize them, we must do that. John A. MacDonald said, 1883, he said, when the school is on reserve, the child lives with its parents who are savages. He is surrounded by savages, and though he may learn to read and write, his habits and training and mode of thought are Indian. He is simply a savage who can read and write. It has been strongly pressed on myself as the head of the department that Indian children should be withdrawn as much as possible from the parental influence, and the only way to do that would be to put them in central training industrial schools where they will acquire the habits and modes of thought of white men. Now, that's terrible. That shows where he was at. Not to say he didn't do better things in other areas. This, terrible. But imagine what I just said about Bill 89 and the comment from the Minister Cotu. You could reread this one like so. When the school is on reserve, the child lives with its parents who are religious fundamentalists. The child is surrounded by religious fundamentalists, and though he may learn to read and write, his habits and trainings and mode of thought are fundamentalist Christian. He is simply a fundamentalist Christian who can read and write. It has been strongly pressed on myself as the head of the Department of Inclusivity that religious fundamentalist children should be withdrawn as much as possible from the parental influence, and the only way to do that would be to put them in central industrial training schools where they will acquire the habits and modes of thought of enlightened men and women and gender diverse people. You can imagine the same sort of thought. I don't have to change many words for it to work today, right? This is what Minister Cotu said. I would consider it a form of abuse when a child identifies one way and a caregiver is saying, no, you need to do this differently. If it's abuse, if it's within the definition, a child can be removed from that environment and placed in protection where the abuse stops. And we now know I know personally, trusted sources where children aged 11, 10, and 9 are being removed from their homes in children's aid societies in this province and being placed in foster care in order to start socially and also chemically transition to the opposite gender because their parents don't support it. Okay, we're repeating the same idiotic mistake that we made 150 years ago. And of course, children are confused, and of course they're expressing this confusion because we tell them there's no such thing as girls and boys, and we use this gender unicorn thing and confuse them even more. And of course, a confused child who goes to a public school, if they say to their teacher, well, teacher, I think maybe I'm a boy in a girl's body, but my parents really don't like that. Well, if that's abuse, under the abuse laws, child abuse laws, you have a duty to report, right? If you're a teacher, and you know or have a suspicion that abuse is happening at home, you have a duty to report that, right? So a lot of these, they're well-meaning, but they're creating havoc. They're well-meaning teachers, and they're well-meaning CAS workers, but they're like, oh, we're told that this is abuse, and so we're going to intervene. Bad ideas have victims. Okay, so that's Bill 89. It's interfering in parental relationships. We're going to have to be very aware of this as a Christian community as we move forward into the next decade. 2019, there's a court case in British Columbia, AB versus CD, where a father was charged with family violence for refusing to refer to his daughter as his son, or not using his daughter's new name instead of the name he had named his own daughter. And then in 2021, Bill C-4, which is a so-called anti-conversion therapy bill, it passed into law, making it a criminal offense to pastorally counsel a person to live according to their biological sex. And then I'm going to just touch on this case here, BJT versus JD from the Supreme Court of Canada. This just came out last year. It involved a tough case of a boy, 5 years old, in Prince Edward Island. And there's a family dispute between his biological father living in Alberta and his grandmother living in Prince Edward Island. So the boy was raised by his mother for a couple of years, but his mother was separated from his biological father, and his mother ended up being unable to raise him, and so his grandmother actually ended up raising him for his first 5 years. But when he was 5, his biological father found out that he existed. And so the biological father said, well, I want my son to live with me. And so a PEI court said, yes, okay, that's the way it should go. You're his dad, so we'll put the child in Alberta. So they upheaved this child's life and pull him out of his grandmother's home where he's lived for 5 years, and they send him all the way out to Alberta, and he starts living with this man who was until then a stranger for the first 5 years of his life. He went to the Supreme Court of Canada, and the Supreme Court said, no, you got this all wrong. The best interest of the child should dominate, and so the child's going to go back to his grandmother. That's a stable environment that he's known. And that might be the right decision in this case. Family law cases are very messy. They're all fact-dependent, okay? So in this case, that might have been the right decision. But when you're at the Supreme Court of Canada, they often opine on the broader principles of law. And one of the things they said, when they're deciding whether or not this child should go to his biological dad or to his grandmother, they used this phrase. They said that biology is an empty formula. Biology is an empty formula. What they meant by that is, so what if he's the biological dad? This is me in my own words, but that's basically what they said. Who cares that he's their biological dad? Biology is an empty formula. They build on that, and they said things like biological ties often lead to courts considering parental preferences rather than the child's interests. The child's bond is higher than biology, and there's no magic in a biological tie. The only thing that matters is close psychological bonds. See, we are essentially psychological beings, not biological beings, is what they're saying. And then biological ties, they say, are difficult to articulate because family institutions have undergone a profound revolution. So it's the state that's revolutionizing the family as an institution, and now it's the judges of the law. They're saying, well, we've revolutionized the family, so why should we even give too much credence to biological connections at all? Okay, that, again, probably the right decision for this particular family. I don't know for sure, but that's my sense. But still, this other opining on the broader principle that biology is this empty formula is a step too far. It undermines the biological connection that you may have with your own children. Bad ideas have victims. And just to be clear, it's not that I have this animus against non-biological children because one of my children is adopted. I don't have a biological connection with one of my 3 children. Adoption is a beautiful thing, creating beauty out of tragedy, and so I'm not trying to give a total preference to biology over non, but we do have to recognize that the biological connection is very important. Okay, well, what about religious codes and institutions? And can you remind me when I'm supposed to be done again by? I'm supposed to be done by 2:30? Oh man, that experiment over there took way too long. Okay, very quickly, I'll hit on religious codes and institutions. I'll probably skip pastoral counseling and prostitution. I want to play this clip, okay? So this is a clip from the Supreme Court of Canada. It's involving the legal dispute about Trinity Western University's law school, okay? So Trinity Western University was going to start the first ever Christian law school in the country. Today, there's no Christian law schools. There's only secular humanist law schools in the country, okay? So it's the first ever. And there's a big dispute because Trinity Western University, as a Christian evangelical school, they have a code of conduct that students and staff need to sign, and it says, I'm not going to look at pornography, I'm not going to smoke and drink, I'm going to be respectful and not plagiarize, I'm not going to be sexually active outside of a marriage, and by the way, marriage is between one man and one woman, okay? And a bunch of other stuff. It's a 5-page document. they hone in on this definition of marriage and say, we can't have a law school that trains people to become lawyers and at the same time that they're contributing to this homophobic idea that marriage is only between one man and one woman. So the case goes up to the Supreme Court of Canada. This is the opening argument, okay? So the lawyer for Trinity Western University gets up. He's going to start his argument. At the very beginning of the hearing, he hardly begins, and one of the judges interjects.
University et al. We'll call on you first, Mr. Boonstra.
Chief Justice, Justices, I rise this morning to make a brief opening on behalf of Trinity Western University and Braden Volkanant. This opening applies to both appeals that are before you today, and I will not repeat the comments that I make in my brief opening this afternoon when I bring my submissions in the British Columbia appeal. And after my opening, Mr. Staley will address the Ontario appeal. What the law societies had to decide was whether they would accept graduates from a Trinity Western School of Law for the purposes of admission to the bar. The question for these appeals is whether and to what extent the evangelical Christian community that exists at Trinity Western University will be respected and accommodated by the law societies in making that determination. And that question has to be...
I'm sorry to interrupt you at this time, is that the only question really an issue? Because if you can bear with me just for a second, it seems to me that it's more complicated than that. In other words, your client, Trinity College, as a well-known school, has a special covenant, special program, according to which a student has to accept the conditions of this covenant. And so students who don't share the same sexual orientation has two choices. First, he or she has to hide a real sexual orientation, and which is not really a good thing, and which will bring some pain and suffering, and could attack the human dignity, or could decide not to attend the school. That's one thing. But the other thing is, Trinity College is seeking the approval or the help of the Law Society. And the Law Society is a public entity. And the first mission of the Law Society is to protect society, protect public interest, and uphold the rule of law. So how can you reconcile this obligation of the Law Society to uphold the rule of law and then the Charter of Rights with obvious discrimination, which is brought by the covenant of the Trinity College?
Yes, Justice Wagner.
That's Justice Wagner at the time, but he's now the Chief Justice of the Supreme Court of Canada. And you notice the language that he used when he posed his question to Mr. Boonstra, a lawyer for Trinity Western. He said, that a person whose sexual orientation is would make it difficult for them to sign the community covenant, which he called a sexual covenant, which is, it's not what it is, it's a religious covenant. Sex happens to be one line in the 5 pages of the covenant. But anyway, it says the sexual covenant, they can't sign it because if they did, it would cause them to have to hide their true identity, which would cause them harm and suffering and pain. He used the word pain and suffering, and will harm their dignity. That's what he said. Okay, so all of those cultural ideas that I talked about in my first lecture, that's all came out of his mouth just now, and he's one of the 9 Supreme Court of Canada judges, and now is the Supreme Court of Canada Chief Justice, the Chief Justice of the country. That's where he's at. The idea that a person might actually, of their own accord, even if they were to identify as gay, could potentially go to law school for 3 years and not engage in homosexual sex is beyond the pale for him. You can't even imagine that could be a possibility. For him, it's so intrinsic to the person's identity that they have to be able to do that, that we're going to make sure that this university does not have its law school. And so, of course, as that institution is forced to bend the knee to the new ideology, then other institutions will be expected to as well. Justice Campbell, who's a lower court judge, a superior court judge in Nova Scotia, he actually had ruled in favor of Trinity Western in an earlier case. And he had said this beautiful line. He said, "The charter is not a blueprint for moral conformity." But really what we now have is that the charter is, in fact, a blueprint for moral conformity. And judges and government actors seem happy to use it to compel institutions to follow along with the new moral language of our day. One other institutional example then is, you may have heard about, I should take the text down because you'll be tempted to read it. You may have heard about the Canada Summer Jobs issue. So there's a program that's federally funded where if you want to hire summer students as interns or as workers, you can go to the federal government, ask for a grant, and say, hey, we'll hire these interns, give them some real job experience. They learn, they get more experience. We benefit from our ministry because we get these people working for us, and the federal government, just gives you money for it. But then a few years ago, they stopped giving money to Christian institutions that refused to check a box that they affirm reproductive rights, which is code for abortion, and then also that they had to affirm, principles around equality and diversity and inclusion, also around sexual codes. And so, of course, a number of churches said, we can't do that. They reworked the program a little bit, but one church applied to Service Canada for this grant. And Service Canada delayed for a while, and then they wrote back, and this is what they wrote. I'm quoting from the letter from Service Canada to this church. It happened to be a Baptist church. Service Canada found information in the public domain that raises concerns regarding your eligibility for this federal grant. A review of your website's belief statement indicates we believe God's word teaches and confirms that marriage is the union of one man and one woman to the exclusion of all others. It then said, this raises concerns that the project or job activity restricts access to employment contrary to applicable laws on the basis of sexual orientation, gender identity, or gender expression. This also raises concerns regarding the measures to provide a workplace free of harassment and discrimination implemented by your organization. Right? A Baptist church says, hey, we want to hire a couple interns so we can run a soup kitchen and run a summer camp for children in the inner city. And Service Canada said, yeah, but you believe this thing about marriage, so we're not going to give you any money so that your interns can't work for you and can't run the soup kitchen and can't run a camp for underprivileged children from the inner city. Okay, again, bad ideas have victims. Who bears the brunt of that decision? Well, the church in a sense, but frankly, the church should be funding its own employees to run a ministry anyway. The federal government shouldn't fund Christian ministry. That aside, though, the ones who pay the price here is the inner city children who don't get to have a summer camp that summer because of this ideological test. Or it's the people who would otherwise benefit from the food kitchen who don't have access to the food because the church can't run the program because the federal government has this ideological test around what marriage is. Bad ideas have victims. I will close. I'm going to skip over pastoral counseling and the prostitution question, and just close again with the question I opened with. Has Christianity been a positive cultural force in Canadian law and policy? It's been up and down, I think, but generally speaking, Christianity has reshaped law in the Western culture so that we take it for granted, ideas around freedom, around equality, around this respect for human rights as it relates to the Imago Dei. And we're now shredding that. We're running it through the shredder. Christianity has been, I think, a positive cultural force, but we'll really feel it when we move away from Christianity and try to develop law without that foundation. So we have to reframe the question from has Christianity been a positive cultural force to can Christianity be a positive cultural force in Canadian law and policy? If you believe, as I do, that God is good, and if you believe, as I do, that God designed sexuality and the family beautifully and for a good purpose, including the protection of children, and if you believe, as I do, that God guides us through prohibitions in His Word and prescriptions in His Word because He loves us and because He wants us to flourish, and if you believe, as I do, that Christians can't keep this beauty and this truth to ourselves, then I believe that Christianity can, once again, be a positive cultural force in Canada today. But in order for that to happen, we as a Christian community must be confident in the goodness of the true God who is there. Thank you very much.
Thank you very much, Andre, and for the work that you and ARPA Canada do. We are moving to refreshment time and then breakout sessions. We will officially begin the breakouts at 2:50, okay? 2:50.